Today we're going to be talking about provisional waivers, or an I601A, and how to optimize a successful outcome. Today we have managing attorney Ruby Powers and assisting attorney Cynthia Milian. Ms. Attorney Powers is a board-certified attorney. She has had PLG for a while now. She founded her firm since November 2009, and she even worked from Dubai and handled cases all the way over here. So you guys know she's kind of a pro with our remote working now due to COVID. And Ms. Attorney Cynthia Milian, she has worked with Ms. Powers before and is now one of our attorneys, and is the vice president of MABA, the Mexican American Bar Association of Houston, which is super cool. Both of our attorneys are bilingual. And yeah, they're also like super smart and super cool. So today we're going to be talking about, like I said, provisional waivers and the I601A. So Ms. Ruby, would you like to
Yeah,
lead?
thank you so much, Dana, for that really generous intro. We're going to give you an update about, just get a guidance, a background about provisional waivers. Really, it's one of the few options for a lot of people right now who might have entered illegally or without inspection. And, you know, a lot of people get a little overwhelmed by the concept of having to have their loved one or themselves leave the country briefly for consular appointment. But we're here to tell you we've been doing this for many years with very high success rate, and we've been able to bring our clients back and not have to be outside the country very long. So we're going to give you an in-depth review of the provisional waiver process. This would probably be really good for either our existing clients, potential clients, people who want to get a second opinion. Are they really doing what needs to be done with their case? Maybe they have another attorney and they're just trying to get some information, or they're looking for an attorney right now. We want to go ahead and give you that information. So we're going to talk about inadmissibilities and waivers needed to overcome them. Really, what is the provisional waiver and eligibility, screening, the practices that we use, extreme hardship, discretionary factors, sample timeline, what is inside a 601A waiver, and talking about the public charge, some other key points on how to work effectively, and thoughts at the consular appointment, and what happens if the I601A is denied, and alternatives to waivers. So we normally present this to other attorneys, and we're going to give you from a just a perspective so that you can be more empowered. So I've been doing waivers for 12 years, and the way I look at looking at them is that the government is trying to scan you. I sort of use the analogy of like they're like laser scanning, like they're trying to figure out, do you have any problems? Should we keep you from coming in? Because the other way people say is the immigrant is knocking at the door and they're saying, let me come, can I come in? And the government's like, do you have any issues that we need to address? Like crimes or entered illegally, or maybe smuggled some family in, or what have you. So I like to look at it like that. And step one is scanning. What would be inadmissibility issues, real, and I say perceived because I mean, maybe the government thinks it, and maybe they won't, but you need to be prepared if someone might think it is an inadmissibility. So you have to be thinking ahead, and that's our job, to sort of be that worrywart who's like, we don't know, so we'll have to be prepared, and we need to get think about all the options. The second is check to see if you're available for a waiver. That doesn't take too much effort, and we pretty much have all that memorized. And then step three is, do you qualify for the waiver? And we're going to talk about what the extreme hardship looks like in qualifying relatives. So this is what we're going to talk about. But scanning, screening the person, the potential client, the immigrant, is like so critical. And Attorney Milian is going to give us a big heads up on what does that look like.
So as Attorney Powers said, there are several things you want to screen for before you see if you're eligible for a waiver. The first thing that we want to look at is whether there is any unlawful presence. This is something that came into being after April 1st, 1997. And unlawful presence essentially means it's the period of time when you're in the US without being admitted or paroled, or when you're not in a period of authorized stay. So for example, if you have an I-94 that expired March 30th, 2020, and you're still in the US right now, you're essentially accumulating unlawful presence. So there are several bars, right? So if you've been in the United States for 180 days, and you leave, you've accumulated unlawful presence. So 6 months after your I-94 expired, if you leave the U.S., then you are barred from re-entering the U.S. for 3 years. So let's say that you overstay for a year, or you're unlawfully present in the U.S. For over a year or 10 years, however long, but beyond 1 year, then you are barred from returning to the United States for 10 years. And let's say that you've had to go before an immigration judge, the judge has issued an order of removal, and you've been ordered deported, you leave the country, and then you unlawfully enter back into the US, then you're ineligible for a waiver for 10 years. So a lot of people refer to it as a permanent bar, but essentially what it means is that you have to wait outside of the US for 10 years before you can apply for anything to re-enter back in the US. So this is a little tricky, and we don't expect for you to have this memorized, or for our clients to know which of these waivers will be applicable to them. But later on, we're going to discuss when or how we can determine if a person is going to be barred, or if any of these waivers will be applicable to them if they've had encounters with Customs and Border Patrol, or have had to go before an immigration judge.
And the key trick here also to just supplement, piggyback off of this, is to tell the truth to your attorney. Because if I often in my 12 years of practice have heard people say, but how do they know about an entry, or what if we don't tell them? And I'm like, no, it doesn't work. The government knows far more than you can imagine about your entries and exits. And if you say you're somewhere, then you have to have proof that you're there, or the absence of proof that you're, the other place. So you weren't somewhere else. So just telling the truth is so critical, and to your attorney, so that we can help screen you to the best of our abilities. So we wanted to do some hypos and let Dana just sort of walk us through some ideas so we can help cover this.
Okay, well, thank you. So these are some hypotheticals. So the first one would be entered without inspection in 1996, one time without problems and never left. Eligible for provisional waivers if have the qualifying relative and visa available. So what does this mean?
Well, so we sort of cheated. We gave you the answers so they are eligible because they entered one time, and it doesn't really matter if it was before or after, because they stayed after. We're assuming they stayed after April 1st, 1997. They accrued the 10-year bar by the time they left. And of course that does matter, but we're assuming that they left like today, for example. So in this case, it was one entry, no problems at the entry, and then they overstayed and then they left. So all things being equal, they're qualify.
Okay, so the next hypothetical. Let's say this person entered without inspection in April 1st, 1997 and stayed 6 months and then left. And then entered again without inspection in 1998 and never left. So that would mean?
And then they're coming to us talking about provisional waiver, and they're saying, what would happen if I proceeded? Jenny, Lilian,
Yes.
do you want to cover that one?
Yeah, so they wouldn't be eligible for the provisional waiver. So they accumulated 180 days and left, and then they came back and never left. So they have more than one entry, and they've accumulated unlawful presence the first time. So they're not going to be eligible for the provisional waiver in this scenario.
Yeah, and it's also important to note that this gets really technical, but a person doesn't accumulate unlawful presence for the 3 and 10-year bar when they're under 18, but it does affect the permanent bar. So a lot of attorneys make this mistake, and they say if you came when you were a kid and you had this unlawful presence time and you left and you came back in, that doesn't count, but it does. And I'll tell you that most of the cases for provisional waiver go through Juarez in Mexico, and they're the largest consulate in the world for U.S. consulate, and they understand the permanent bar like the back of their hand. So you don't want to mess with them. They understand it, and that's why you have to screen properly. Now, again, we're giving you some general concepts, but it's always good to talk to an experienced immigration attorney. And if you have doubts about your own attorney, you might want to get a second opinion, because this is so critical. We don't want anybody to get stuck abroad. So, Hypo 3.
All right, so let's say we entered without inspection in 2001 and received voluntary return the same day and returned back home, and then entered again without inspection in 2002 and then just haven't never left. Would be the case there.
Yeah, so they would be eligible since a voluntary return is not necessarily seen as an order of deportation. And because it was, the return was on the exact same date, it's not something that'll count against them. So they would be eligible for that provisional waiver. They're basically going to look at, that they had their first, well, you're still going to disclose that 2001 entry and that voluntary return, but the time that they've started accumulating the unlawful presence in the U.S. is in 2002.
Yeah, and a lot of times people think that provisional waiver is only for one entry, but you can have multiple entries. It just gets a little bit way more complicated. We've had maybe 1 or 2 people had just a couple of voluntary returns. The other thing from experience is when someone says they were apprehended at the border, we go straight to FOIAs to find out was it a voluntary return, voluntary departure, expedited removal, or what have you. And so that's why I always say, like, to be able to predict, to work on your future, we need to know what happened in your past. And so that's something to note. And we said voluntary return, not voluntary departure. And a lot of people don't know what it was. And it was a long time ago. So we have that discussion all the time. So Hypo 4.
So the fourth one would be, so let's say I entered without inspection at age 10 and then received DACA before the age of 18, and I've kept my DACA. What would be the case for me there?
Well, so we talked about entered at 10, so you didn't accrue unlawful presence until you turn 18, but they got DACA before 18, so that means DACA prevents you from accruing unlawful presence. We have clients like this, actually, and then they later married an American and they're doing the consular processing, but they haven't accrued unlawful presence as long as they keep their DACA going, and they had it before they turned 18. So this is exciting when we see these, because then we don't have to do the waiver. It saves some money and time, but it's also about maintaining the DACA, and you had to get it before you turned 18. So it doesn't always exactly work. We don't see it that often. Okay, well, so and hopefully this isn't too much legalese for you. We're trying to make it this information as approachable as possible. So the provisional waiver, so I've been practicing before the provisional waiver existed. I did a lot of waivers. The way it used to work was, so imagine 1997 is when unlawful presence started, and like Attorney Milian explained, the bars happened, and the intention was really to keep people from coming in. But what happened is basically people got stuck, and I would say almost trapped inside the country. It sort of depends on how you imagine it. So it had the unintended result of actually having the 10, 11 million people who actually are inside the country, and if they leave, would be barred, and many people don't have qualifying relatives. So people had to do the process, and they'd go to like Mexico, Honduras, Guatemala, wherever, and they would have to submit their waiver there. This is pre-2013. What would happen is the waiver would take 1 or 2 years, and it would be adjudicated by different people around the world, and it would be different. So I was getting really good at the different consulates and posts and knowing specifics. And then in 2013, under Obama, they consolidated it, and they also gave us, because they were going to do the review inside the country, but they also decided to give us a chance for those people who had super clean cases. They would let them get their waiver approved before they left the country, so they wouldn't have to do that waiting abroad. And it was really a focus on family unity. And so I'm really grateful for that. So that's more than 7 years old. And I remember this because one of my second child was born right when the provisional waiver came out. And I can still remember how I was like, oh my God, I'm so excited. And then I had a baby and at the same time. So it was like, hey, what am I going to do? I was trying to get back to the office. So anyway, everyone's like, well, do I have to leave the country? You know, do I really? I mean, I get that question almost every time I do a provisional waiver consult. And the answer is yes. Unless we're doing something else, if you're doing the provisional waiver, you still have to leave to finish the whole thing. And it's at the end of the process when we've already screened, we've gotten things approved, and we're feeling really sure that you have a good chance. Of course, it's a provisional, and they say that for a purpose because it's still provisional. So anyway, this is a great program, and I'm so happy for it. And it's really sort of like this hidden gem that I think some people discount because it can take a couple of years and it might seem like it's costly, but you know, when everyone comes back, they're so happy. They have their social, they have their driver's license, they can get a better job, a better paying job, and they don't have to worry about the future as much. And they, you know, so many of our clients put their lives on hold because they're waiting for their green card, and we're so happy that people have this opportunity. So the key point is that you have to have a legal permanent resident or U.S. citizen spouse or parent, not a child. So spouse or parent. So if I had a U.S. citizen parent that would suffer if I were to be sent to, let's say, Mexico, then I would have to explain it. And usually when you use a parent, it's because you are the caregiver for that parent. And you live close to them and you take them to the doctor's appointments and things like that. Or spouse, I mean, that's a little, you know, a lot easier to prove that hardship, that they will not be able to financially, emotionally, medically, mentally, you know, will be harmed if you have to live, if I had to move to Mexico and my spouse had to stay here in the United States, or there would be, it would be very difficult, extreme hardship for my spouse to move to Mexico with me. So these are the key points. You need to have so we have to screen you to make sure you're eligible. There's only one problem is unlawful presence. And then we also need to make sure you have a qualifying relative. And then we need to make sure that you can show that hardship. And, you know, I said it was open in 2013, and then they clarified and expanded it in 2016 to give, and this is a little bit more detail than probably a typical talk, but they gave it available to more family members for the visa availability. So we were able to use like F2A category, lots of different categories. It didn't have to be in, immediate relatives for the visa availability. And there was, they would quit denying things just because of reason to believe. And then some people in very limited circumstances could, if they had a removal order, could use it. I would say most of this, what I'm mentioning, either is irrelevant or we should talk about in a consult because it's very specific, but they were improving it. And so well, this is really what I think the most important thing that your attorney would do for you is to screen you. And the questions that they ask, you might be like, why are you asking me this? Well, we're asking for a reason, you know, like whether or not the American was born in a hospital, it meets because was there a midwife birth? Are we gonna have issues there? You know, so there's a lot of crazy stuff we might ask you, but it's you know, it's not because we're like, you know, we're like, I don't know, annoying or you know, whatever. We're really trying to help you and make sure that we're screening you properly. So these are some of the questions that we usually ask, and Attorney Milian, feel free to jump in wherever, but you know, have you ever been encountered by immigration anywhere? And you know, and usually the immigrant, we might not be talking to the immigrant in the consult, or maybe they're at work or whatever. We really need to talk to the immigrant to make sure. Were you ever detained, fingerprinted? We do FOIAs, crazy FOIAs all the time, to find out what we can find out what happened. Did you give your real name? Did you ever get public benefits? Has anybody been in the military in your close family? Because we're trying to see maybe you're eligible for parole in place. Does anybody have tattoos, the beneficiary? Because you have to be able to explain what the meaning of them. They're really just trying to make sure they're not gang related. How did you enter? Did you come with other family members? Did you you pay somebody? Have you been doing your taxes? Did you do them properly? If you're married, did you do head of household? Because that usually doesn't show that you're really living together. But did you do the married filing separate or married filing joint? They look to taxes for lots of things, good moral character and proof of the relationship. And then do you have any crimes anywhere in the whole world? Not just, here. Like they'll be like, sometimes we'll ask, like, have you had any crimes? And they'll just think America. We're like, no, United States. We're like, no, anywhere. We need to know anywhere. Or they'll say, have you ever been married before? And sometimes those people will say, just the United States. Well, no, we want to know your whole life, any crimes, any children, any spouses, let us know, because we need to know that. And the more truthful you are to us and give that information, the better we can serve you and make sure that we're put you on the right path. And like Attorney Milian was saying, we have to calculate the unlawful presence. We need to know when you entered and exit. So that's why when our intake sheets, we always ask entry, exit, talk to me. And if you don't know those dates, we're going to make you go double check. If you remember you left for a party, a quinceañera, a funeral, or this and that, we need to know. It was a Christmas, what happened? So we might, usually I remember seeing a lot of my clients they're like, I don't remember, yeah. So that's why you need to think of those dates before you come in. So we can give you the best advice. And then we also check if you've been a victim of abuse or crime, you might be eligible for the U visa or VAWA. And then also it's good to know, do you have any other U.S. citizen or legal permanent resident family that, because maybe you don't have a qualifying relative now, but maybe you're only a couple of years away from somebody getting a green card that could help you. And the other thing we should always check is double check if you're actually a U.S. citizen or not, because sometimes, not that often, somebody might be a U.S. citizen and they don't even need to do this. So that's why a lot of these questions lead to, it's just like you go to a doctor and the doctor asks you lots of questions and they want to run tests. This is sort of like us running tests and asking lots of questions. And that's the reason why we do this. It's not because we're nosy, it's because we want to help you. So Attorney Milian, what do we do now that we've screened them and we found out that they have a qualifying relative, and what should we do now?
Yeah, so after we've determined that you are eligible for a provisional waiver or almost eligible, then we want to screen to see what hardship you're trying to prove, whether it's medical, financial, emotional. And extreme hardship, it's not a definable term or fixed term, but it all just depends on the facts and the circumstances of each case. We filed waivers focusing on, the hardship that a spouse could potentially face if he were to go to a country that he's never visited before, and if he's a professional here in the US where he won't be able to continue his career over there. We've also focused on other ones where a parent is probably ill to the point that they're bedridden and they can no longer continue, they wouldn't be able to live without their son or daughter here in the US. So it's very fact specific. Each case is different. So how do we prove hardship, right? So we look at several factors: the age of the person of the qualifying relative, the family ties in the U.S., the health of the individual, if there's financial factors. We look at if this person is also is of special assistance to the U.S. or the community. And they also look at, the individual's position in the community. So, as Attorney Powers mentioned, the provisional waiver has been around for a few years, and in the last few years, we've gotten clarification on what exactly is extreme hardship, or, how does USCIS interpret it? And, there's a lot of information on here. I'm not going to read through it all to save you all some time, but this is something that we usually screen for in a consult. We'll ask, if the qualifying relative is a parent or if it's a spouse. We're going to go into details, seeing, what exactly it is that they suffer from, or what is it that could result in an extreme and unusual hardship if this person weren't to weren't allowed back in the U.S.
And, I just want to say that one of the best things about the clarification, having practiced before the clarification, is that now everyone's on the same page. Used to be one officer adjudicators, hardship was not the same of the other one. And so when they finally came out with a clarification, it just made, with this 2016, so 4 years ago, and it's in the policy manual, it just gave us so much more. And we could aggregate the qualifying relatives hardship. We didn't have to prove the separation and the relocation. We could just do one of the two. And it said, look at the aggregate. So it was just awesome. And so here's just some of the things that we work on at proving hardship.
So there's the health consideration. What specialized treatment is the qualifying relative receiving here in the U.S. that they can't receive in the country of the immigrant? The financial considerations as well. We said that you can't focus on U.S. Born children, right? But we find ways, like if, what is this qualifying relative? If it's a spouse, what additional costs are they going to have to incur now that one of their spouses is outside of the U.S. and they're having to pay for childcare, or may even have to quit their job to care for the kids. And you have to remember that, whether if it's health, financial, or if we look at the educational or any other consideration or factor that we mentioned, that there always has to be proof to back all of this up, which is something very important. If you, as Attorney Powers has mentioned, if you are thinking about, possibly going forward with this process, or if you have a process that you've already started, one thing that is very important is to always, keep your documents, right? Documents of, medical records, records of, if you've had to visit a psychologist, or if you had to go to therapy. All of these things are very important, so that when we compile all the evidence, we don't just mention it, but we have proof that can back all of this up. Because believe it or not, USCIS will, they will issue RFEs, requests for evidence, for things that you may claim but not have evidence to back up.
That's a really good point. So everything you say in your affidavit, you need to have evidence, or else we really can't talk about that as one of the prongs of your hardship. And that's also a really great point about, whether or not you're planning to do this now or maybe later, keep collection of these documents. Just save them, scan them, dump them somewhere to keep them organized, so that when the time comes, we have them. So, it's really about balancing things. Like if you came when you were young, sort of like a dreamer, then they're going to be a little bit less hard on you because you didn't have control over that. And if you have any crimes, which really you can't have that many and still do provisional waiver, then that could be looked upon badly. So these are adverse factors. Positive is, how many family members do you have in the U.S.? Is everybody here? Then, you have more of a life here than somewhere else. Or how long have you been here? Have you shown employment? Have you been involved in the community? So we like to look at everything, and to put the best foot forward. So what does this look like? What do we, okay, you've talked about screening, you talked about qualifying relative, you talked about hardship. So when people, potential clients have a consult with us, we have a handout, and we have something a little bit more detailed than this with filing fees and legal fees. But, usually the scenario is immigrant came in one time, married an American U.S. citizen, and now they're like, what do I do? So that's this timeline I'm showing you. So let's say the immigrant, let's say his name is Joe, and he married Jane. just saying. So Joe married Jane, and Joe, so what now, Jane needs to show that she's a US citizen and that she's married to Joe, and they do the I-130 petition. They have to wait for it to get approved. We've seen everything from a few months this year during pre-COVID time when they had a lot of time to do stuff to taking a year. So you really want to get that done. And then the fee bills will be sent to the National Visa Center. You have to pay those, and then we show proof that they've been paid when we do the waiver. The provisional waiver is why Jane can't live without Joe, and she can't move to, let's say, Mexico, and why she can't, and or why she can't live without Joe. She's got kids, she's got a demanding career, she has a home mortgage. She's going to have a hard time being able to take care of the kids, do everything, plus COVID, if they have to have 2 households. So we submit that waiver, and that usually can take, what, a couple of months, maybe more, for clients to get all their documents together. So you have to imagine, we're not just talking about how long does it take for the government to process, which fluctuates a lot, but it's also the client, because many of our clients, they're busy, they've got kids, they got jobs, they're trying to hold on to put everything together, and you really have to make this a priority. So it might take maybe 6 or 9 months, and it always changes. So the provisional waiver is pending. Then you do the National Visa Center, which is about the DS-260, and the I-864, which is about money and where have you lived and worked. And then eventually you're going to get a visa appointment. Now, we're filming this on August 7th, 2020, but most of the consulates are on very limited services and are on hold for this. But once you get an appointment, our clients leave the country, go to the medical exam, visa, biometrics, and then they're reviewed by the officer. If everything is well, they're giving a visa in their passport, and then they'll get that, and then they can come back into the country. I just said it really fast, but this can take about 2 to 3 years. And it's definitely worth it, especially if you have, I mean, look at us like experienced coaches. We know how, we have so many clients ahead and behind you. We can tell you the trends before most people know about it, because we're in touch with this process. So what are some of the things, Attorney Million, that we would normally need to put in this I-601 content application process?
Yeah, so within the I-601A, you want to include supporting documentation like we were talking about. So there's a cover letter. Usually what we do is we draft a legal memo or a brief that briefly touches on all of the hardship factors that we're going to focus on, and we'll refer to all of the evidence that's included. So we include obviously the forms, the filing fee. I believe, I think it's $680 right now. Don't quote me on that. But
the filing fee for the,
for the I-601A.
Yeah, 1 second. It's a 630, I believe.
It's 630.
Yes.
Okay. And is that one of the ones that's going to go up?
Yes, and this is something we want to let you know, and why we're doing this now is right now it's 630, but it's going to go up to 960. So $330 increase on October 2nd. So again, it's 630 right now, and it's going to go up to 960 on October 2nd.
Yeah. So keep that in mind. If you have an I-130 that's already approved, if you're at this stage, right, then you want to make sure that you file this, in the next month or so, just in case there are any rejections. Along with the filing fee, we'll also include letters and affidavits from the qualifying relative with specific information that we like to include. Like I said, an index of evidence, and also include all of the evidence that is going to support what has been submitted or what you state in your brief or in your letters. So it's a very thick packet that we include or that we send off with the I-601A.
Right. So, and a lot of people say, are you going to write my carta or the perdón or whatever, like we have our own memo, but we also need our clients to write their letter. And we need it in your own words, and then we take that and we can help edit. But really, we need your cooperation and help. And a lot of times, what happens is that you write things our clients write things that they didn't tell us in the consult, and then we're like, oh my gosh, this is really good for the waiver, you should elaborate this, get some more proof. And so it's really a work in progress, all the things we do. So public charge, not a fun topic, actually. Okay, so we've had the I-64 for a long time, and that's to prove the that you're not a public charge. It's affidavit of support, financial support. And well, about a couple years ago, I don't know, it's been run, I'm losing track of time. The consulates, the Foreign Affairs Manual, the State Department changed their interpretation, and versus USCIS, because Department of State versus Department of Homeland Security. Anyway, what I'm going to say is that they got a little bit more involved in depth, a little bit made it harder to meet the standard of public charge. And so that's happened. So really, we don't like to focus a lot about the financial hardship, because sometimes you might be hurting yourself when you proving that you're not going to become a public charge. So we have to walk that line very delicately. Basically, some of the things that the consulate can look at, and I've been to tour at the Juarez consulate. They basically said the I-64 was the affidavit of support. Normally they would look at the four corners of that form and say if you meet it or you didn't. But then when they made this change, they said, no, we're going to look at the whole picture. What's your age? Do you have any health conditions? Are you employed now? Would you think it's likely to get a job when you come back, the immigrant? You know, are you barely making it? How many household members are there that you're taking care of? Is anybody getting benefits? And, you know, again, everything I'm saying, I'm thinking in the back of my mind, we're in economic troubled times and we've got COVID. So this is really hard to put a burden on our clients. So this is one thing. And then just they had recently in February made a requirement to do a public charge questionnaire. And then a week ago, they said there was an injunction that said that you don't have to do that anymore. So it's lots of changes. The bottom line, and you should always just make sure you check in with your attorney what's going on at that moment, is that it's really important to know that you shouldn't have, you should try to be financially independent and not take public benefits, but sometimes certain public benefits are not an issue, especially for your U.S. citizen child. It depends on what algorithm they're calculating it. I would just say, have a talk with your attorney or let us talk with us about this. But the reason why I'm saying all of this is because if you get found inadmissible for public charge, then that means they can revoke or deny your I-601A at the consulate. And that is a concern. Sometimes in the past, we just had to get a joint sponsor, but we've seen that recently that they've been just denying it and making you do a whole nother an I-601 while you're outside the country. So just make sure that you're aware of that. So we're getting closer to the end, and you know, what are some of the things that we should be thinking about and working effectively? We've done this a lot, and I know we just got a waiver out like this week that Attorney Milian and I were working on. You know, I would say making sure who's the point of contact. Are they going to be watching their email regularly? Are they going to be accessible by phone? How well do you work with technology? Are you more of like, we can do this remotely? Because we've had clients where we never saw them ever in our whole lives. Especially when I ran the law firm from Dubai, it was so normal. And right now with COVID, we really aren't having clients come in right now. Or we need to find a way to, like, with more paper and maybe you mail stuff and you don't have a scanner or printer. And we can work with you, we just need to know that in the beginning. I always say you should submit the majority of your documents at one time. It's like pieces of a puzzle. Is it easy to do a piece of a puzzle if you get one piece and then maybe another week another piece and another week another piece? Do you know what it is? No. It's better to get like about 80 to 90% of everything and then in a box, and then we go through it, and then we're like, oh, and then, because the other thing that happens when we review things multiple times is that we get a little bit desensitized from seeing it from the adjudicator's point of view. And then that makes us not be able to see the big picture. That's why in our office, we actually have the process where everything is reviewed at least by 2 attorneys, if not more people in the office, because the person who prepared it and then 2 others, we want to make sure that we're looking at it from all different points of view. Make sure that a lot of times waivers don't have deadlines, but you need to make sure that it's important to make deadlines to get things done, because if not, you'll be working on this forever, and it might be painful, it might seem costly, but it's really the best thing for you. And everybody needs to know what's in the documents, especially the intending, the immigrant, the beneficiary, because sometimes maybe a spouse will be really involved, and then the immigrant is like, I don't know what's in this packet, and I can't, and they need to be able to defend themselves, because when they go to Juarez or wherever they go, they have about 5 to 15 minutes to explain their story. And we prep our clients before they go, obviously, because we want them to be prepared, and these questions are not just, they're thinking about them for the first time in 20, 30 years. But it's important that the immigrant is involved. And then we, as a firm, we check in with you after the I-130, after the waiver, after the MVC, the whole way through, because things change. We need to double check you qualify, and maybe there's reform and you don't have to do this. We could move you over to something else. So what are some of the other things that we have to consider? Oh, yes. I mean, I think that when you're doing this is that you also have to realize that it's provisional. You go to the appointment, and if the officer finds something else wrong, they can revoke that provisional waiver. And so that's why it's so critical to tell the truth to your attorney, let's say us, so that we can give you the best advice. When you go to the medical, and I did a tour of the Juarez medical exam and consulate, they ask lots of questions about crimes, alcohol, drugs, tattoo, children, because they want to know if you're telling the truth to them. And everything that those doctors in those medical exams report is going to the consular office. They're just an extension of the consular office. So that's critical. They're looking for inadmissibilities about alien smuggling. Did you lie about a child that you have? They even check women to see if they had C-sections, and they ask about how many children they had. They ask about drug usage. They check the tattoos for gangs, evidence of gangs, and they ask you maybe how many beers you have a day, and to see if they think in their mind they're an alcoholic. Biometrics, for example, in Juarez, it's in a shopping center, and there's a lot of people trying to scam the immigrants who are going there. So it's important so that your attorney knows a lot of the different posts. It's not just Juarez, we do client waivers all over the world with our clients all from all over. But just we prep our clients, and then the visa appointment really is really short, and you need to know what's in the packet. So, well, Attorney Milian, this is not what we want to hear. We don't want to, if it gets denied or revoked, but what are some of the considerations a person should make if that were to happen?
Yeah, so the first thing is you want to review the reasons and consider whether you're going to refile. Well, obviously you can't refile the I601A at the point where you've left the country. You would file the I601, and you, depending on what ground that they've denied it on, you would consider whether you want to refile or not. A lot of the times, maybe they made a mistake, or maybe there's something that I601A could still be saved. So you want to immediately, once you get that denial, consult with an attorney, have your family consult with an attorney, and see what was the basis of the denial. If there's something that we can try to argue, make a legal argument with the consulate, and get that denial revoked, and for you to get your visa to enter as a permanent resident. If it's approved but then it's revoked, or if you withdraw your pending application, you can depart the U.S. To attend your visa interview, and you can apply for a waiver abroad. At your visa interview at the U.S. Embassy or consulate, they will make an admissibility determination, and then at that point, you can file the I-601, or if another waiver is needed as well.
Yeah, and I'll tell you one other thing is that if the waiver, you can apply for as many I-601As as you want to, it just takes money and time. And if you get a denial, you're going to look hard at that denial. And I'll tell you another thing that's a little tricky is that sometimes USCIS will approve your I601A and then they know that you're not eligible for the provisional waiver. And that's when they say they got rid of the reason to believe. That's an example of it. If they reason to believe that you're going to get denied at the post, they still might approve your waiver. So we have consults of those lines, and usually what happens is either there was some bad screening done or the client or chose to try to misrepresent the situation. And when I say misrepresent, I just want to mention something. If an immigrant ever made a material fact, misrepresentation of a material fact to an immigration officer, then a misrepresentation finding could be made, and that means that you have it for your whole life. It doesn't go away after 3 or 10 years. And then you need to have the I-601 form for that. So just be aware of that. So yeah, okay. Well, we've talked a lot about provisional waivers. So what happens, what if you're not eligible, or maybe you don't want to do it or something? I don't know. What are some of the alternatives?
Yeah, so, if you have a family member that's serving in the military, you can consider getting military parole in place. Or you may be eligible for 245I if you had someone that filed a petition for you a long time ago, and you're currently married, and your spouse is a U.S. citizen or lawful permanent resident. You may be eligible for 245I, and you don't have to go through this whole process.
And it could have been also for like your aunt or uncle petition for your parent or something. So that's usually one of the things we ask is like, did anybody anywhere in your family ever petition for anyone? and usually you don't know. So you have to go do some digging and follow up with us.
Yeah, definitely something we do FOIAs for. If you were a victim of a crime, or if you've been a victim of domestic violence, you may be eligible for VAWA or for a U visa. There's also cancellation of removal. You have to be in immigration court in order to pursue that, or asylum. And there are other things that you may be eligible for, but this is why it's very important for you to consult an attorney before going into, something like a provisional waiver or just, any benefit that you're trying to pursue, because, like as Attorney Powers mentioned earlier, while you're trying to pursue a provisional waiver, maybe we find out that you're already a U.S. citizen. So it's very important to talk to an attorney that has been practicing, that's experienced, to see what other things you may be eligible for. In case you don't qualify for a provisional waiver.
Yeah, and a lot of times a client will come in and they'll say, I want to talk about XYZ, like provisional waiver, naturalization, or whatever it is. And we usually, I like to take off the blinders and say, let's look at the big picture and make sure that maybe you're eligible for something else. And so it's really important to screen for everything. And fun fact, registry means that you've been here since January 1st, 1972. So most of the people, we've only done one in my lifetime, but most of the people who have been here that long already found some type of way to get legalization of some sort. But there's a lot of other potential, and maybe we'll get reform in 2021. All right, fingers crossed. Make every U.S. citizen, vote, register to vote. Let's do that, people. So our closing practice pointers that we tell other attorneys, we work in our own office, screen well. Screening is like the most important key, besides staying up to date on provisional waivers and having so much experience in it, but screening is super important. Make sure you're checking for other forms of relief, like Attorney Milian has said. Check those tattoos, if there's drug and alcohol problems. For example, if anyone's ever been detained by the police before and they've had photos taken of their tattoos are identified, and then someone tries to get a tattoo removed later on, those are somewhere in the universe of already being documented. So you got to tell us the truth about everything here. Tell us about those encounters within the border. Tell us the truth. Yep, that's pretty much what we're telling you to do. We need to, the more you tell us, the more we can help you. And we usually say focus on 3 to 4 significant hardships to make sure it's really compelling. And like Attorney Millian had said, everything that we say, make sure you have proof to back it up, because that is so critical. These officers look at this stuff all the time and they're like flipping through and they get a little jaded probably because they see this all the time. We want to give them proof and make sure that we can show that you meet the qualifications and get approval. So, wow, waivers in less than an hour. I pat ourselves on the
Really good
back.
stuff. Really good stuff, guys. Well, thank you guys for joining us today. As you guys see, this was a very lengthy topic. And if you guys have any questions or would even like to schedule a consult with our attorneys, please feel free to give us a call at 713-589-2085 or send us an email at contact@rubypowerslaw.com, as you guys can see on the screen. Because of COVID, you know, we're doing over the phone consults and Zoom consults, but rest assured that the quality of service is most definitely there. We also make videos every Friday on immigration topics where we discuss just like we did right now, and we even make Facebook Lives, so feel free to go check those out. We did one on DACA last Friday. And then we did one on asylum, the one after that. So yeah, just feel free to check those guys out. We also have them on YouTube if you want to share them with maybe some friends or family that are interested on this topic. Please feel free. And we also have a newsletter where we send out every other Tuesday that has like all the most recent information that maybe you or someone you know may need to read. So we make sure to put all the hot topics on there for you guys. And yeah, once again, thank you guys so much. Be sure to tune in with us and let us know if you guys have any other topics that you guys would like to hear about. You guys can, you know, comment down below, send us in a message on Facebook, or, you know, like I said, email us or call us. We are here to answer all your questions. And again, thank you guys for tuning in.
All right. Thank you.
Thank you. Bye.
Thank you guys.
Bye.
Bye. At the top, Ruby, you can click end live. There we go. That was good. Hey.
Yay.